Okay, good morning again. For those who just come here, okay, so we are going to resume the lecture in a few seconds, okay? Hello, good morning. Hello. Hello. 1, 2, 3, 4, 5. 1, 2, 3, 4, 5. What happened with my speaker? Oh, I forgot to just turn on the speaker. Just one moment, please. Hello, 1, 2, 3, 4, 5. 1, 2, 3, 4, 5. One moment, please. Hello. Okay, good. Okay, good morning again. Okay, welcome back to class now. We seem to have a long break, okay, but I would like to have some drink. Just permit me to have a drink. Okay, we had about, I think that almost 20 minutes break, okay. I think that should be sufficient, okay. So I hope you are now fresh, okay, except me, I'm not quite fresh. But I need to just continue my lecture anyway, okay? So we are still in part 1, remember the part on the Juristic Act, remember, okay? Before the break, I think that we have seen already that there are 3 expressions, normal acts, legal acts, and juristic acts. I hope that you now, okay, they have formed, okay, sort of, a rough picture of what is a juristic act. Remember, a juristic act, it is a legal act, okay, which is performed by a person with intention to produce the legal consequences. Okay, so that is something described in general. Okay, but the thing is that, okay, after that we will see that in addition to the general description, okay, of a juristic act, we also have a legal definition of a juristic act. In our civil and commercial code, we have also a definition of a juristic act, okay, in the section 149, okay, of the CCC. We will see that later. But before we look at that, okay, we should also look at, the classifications of, classification of the what? Classification of juristic acts, right? If you look at the classification of juristic acts, okay, we may classify juristic acts into first unilateral juristic acts. Ini kamu find here, okay? Ini kamu find here. And bilateral or multilateral juristic acts. Ini kamu 2 ฝ่ายหรือหลายฝ่าย okay? That is one group, okay? The other group of classifications is this. We can classify juristic acts into during lifetime juristic acts and upon death juristic acts, okay? The so-called during lifetime juristic acts, they are juristic acts which are intended to produce, okay, legal consequences during the lifetime of the parties concerned, okay? The parties who make juristic acts intend the juristic act to carry legal consequences during their lifetime, okay? In contrast, the upon death juristic act, it is a juristic act, okay, which is intended by, the parties to carry legal consequences after death of the parties, okay? We will look at, the first group first, okay? The first one is the distinction between a unilateral juristic act and, the bilateral or multilateral juristic act. We begin with a unilateral juristic act. What is it? A unilateral juristic act, or in Thai,นี่คำฝ่ายเดียว okay? นี่คำฝ่ายเดียว It is, in a way, a juristic act which is okay, performed by one party, and it will take effect without assent from or of anybody. That means let's say that A and B they may enter into a juristic act. Okay. The juristic act between A and B may be a unilateral or a bilateral juristic act. It depends. Okay. A unilateral juristic act. It is the one where you get if you make your juristic act. If you make a unilateral juristic act, you need no assent from anyone at all. Okay. The example it is a will or pinagam. When somebody execute a will, okay, let's say that I want to write a will. I want to execute my will. Let's say that now, I do not feel very safe because many people want to attack me. Okay, if you just make, let's say that if you want to make criticisms about the government and the government doesn't like it, okay, it says there that you may be threatened by the government, and if you are worried that, if you're worrying that your life is under threat, okay, you feel that your life is is not quite safe. You want to just make a will. When you make a will, I may make my will. I may say that, well, when I die, I would like all my property to go to my son. Okay, or I want my property to go to whom? To go to the Anunampa. Okay. When I do so, when I say in the will that I want my property, I want all my property, I want my car, I want my house, whatever, okay, to go to whom? To go to A, to go to B, to go to C. Do I need to get assent from A, B, C? No. Let's say that, let's suppose that this is my will. I execute my will saying that I would like to bequeath means give by will, okay? I would like to bequeath my car to my nephew. The result is that, when I die, okay, my nephew will be entitled to that car named in the will. I don't need to get assent or consent from my nephew in order to make that will. So the will, it is a unilateral juristic act, because it is made, okay, without assent from anyone at all. Okay, so a will, it is a very good example of a unilateral juristic act. Okay, I have two microphones, okay, yellow and red, okay, the colors representing Thammasat University. Sometimes I need to, sometimes I use the red one, sometimes I switch to the yellow one, okay, yellow and red one, okay. Maybe I switch to the yellow one now, okay? Because I use the red one for some time now, okay? Good. Again, back to this slide. We're talking about a unilateral juristic act. Remember, a unilateral juristic act. It is the juristic act which is performed by a party without assent from anybody at all. For example, a will. In addition to a will, okay, we have one more example, termination of a contract. Let's suppose that I have made a contract with somebody, okay, and the contract specifies that if, let's say that A and B, the contract is made between A and B, and the contract specifies that if this event occurs, then the A can terminate the contract, supposing that event actually occurs. When that event actually occurs, that is a ground for termination. If I want to terminate the contract, okay, I may just serve a notice to the other party. I may just write a letter to B. I am A, the other one is B. I can write a letter to B saying that I now would like to terminate the contract. When I write a letter to B saying that I want to terminate the contract, the termination of that contract, it is a unilateral juristic act, because I don't need to get assent from B. If I want to terminate, I just rely on the clause in the contract. I may just terminate the contract alone, okay, because the act because the event specified by the contract occurs. The contract says that when that event occurs, I have the right to terminate the contract, and that event occurs already, so that constitutes a ground for termination of the contract. When I want to terminate the contract, I don't need to get assent from anyone, so that my termination of the contract, it is a unilateral juristic act because it requires no assent from anybody. Okay. Now we are coming to the bilateral juristic act นิติกรรมสองฝ่าย and multilateral juristic act นิติกรรมหลายฝ่าย Okay. Looking at a bilateral juristic act first, of course, it is a juristic act, okay, which is performed, of course, by two parties. Okay, as the name suggests, bilateral, by means two, right? So it is a juristic act performed by two parties with mutual assent. The juristic act cannot be performed alone. Okay, it needs to have the assent from the other party. Okay, the most striking example is a contract. A contract is made between A and B. A contract cannot be made by A alone. A contract cannot be made by B alone either. If we make contract, A and B will have to enter into a contract. So a contract, it is a juristic act, okay, which is bilateral in nature, simply because it is performed by two parties with the assent of both parties. It requires mutual assent. And now, multilateral juristic act. Multi mean what? Multi mean many. Multilateral juristic act. That is a juristic act which is performed by more than two parties. Okay. Let's suppose that we have an agreement. But this agreement, it is a tripartite agreement. Okay. Let's say that the agreement is made between or amongst A, B, and C. A, B, and C. Say that this is a tripartite agreement. Okay, so this agreement, it is a multilateral juristic act, simply because it is performed by more than two parties. Of course, it requires assent from every party in this. Okay. Another example of a multilateral juristic act, it is the act of passing a resolution by shareholders. Let's suppose that we have one company A. Of course, company A may have a lot of shareholders. Okay, company A may have 100 shareholders. On a good day, this company would like to increase its own capital. If the company increases the capital, then the company will have to convene, the meeting of shareholders. Okay. So the shareholders will have to pass a resolution for, the increase of the capital. The act of passing a resolution, of course, that is done by many parties, many shareholders, more than two shareholders, so that the act of passing a resolution, okay, at a meeting of shareholders, it is a multilateral juristic act. Okay. Now we are coming to another group of classification. Okay, we have another grouping here. We can classify. Oh, I forget to ask you whether you can hear me all right. Okay, can you hear me all right now? Wait. Where is my mobile phone? Okay, I forgot to unlock my mobile phone here. Okay, so that can I have your permission to just come to pick up my mobile phone? Okay. So if anyone encounter any problem, then you can again tell me. Okay. If not, then I will presume that everything is fine. Right now we are coming to another grouping, or another classification. Okay, we can classify the juristic acts into during lifetime juristic acts and upon death juristic acts. Okay, again, I have mentioned this before. Okay, the so-called during lifetime juristic act, it is a juristic act which is what? It is a juristic act which is intended to produce legal consequences during a lifetime of the person who makes that juristic act. Okay, I make this juristic act. I make this contract. I would like my contract to have legal effects during my lifetime. That means when I am alive. Okay, in most cases, okay, juristic acts are during lifetime juristic acts, simply because the parties who make the juristic act want it to, to produce legal consequences during the life of the party. Okay, we can use a Latin expression here, inter vivos. Inter vivos means between life. Right. In contrast, the upon death juristic act. It is a juristic act which is intended to carry legal consequences after the death of the person who made the juristic act. Okay, if you make a juristic act and you want it to carry, the legal consequences when you die or after your death, upon your death, that is the upon death juristic act. Okay, so the example, and in fact, the very striking example of this is what? Wait a minute, let me just come to our group, private group now. I'm going to make sure that if you send me messages, then I am in the position to see your messages just on time. Okay, now very good. I see myself now. Okay, live. Right. So if you have any problems, okay, if you encounter any technical problem with regard to the audio signals, the video signals, or something else, okay, just bring your attention to me so that I can just make adjustment, okay, in the due course of time or in the nick of time. Okay. Good. Now, okay, so far so good. Again, upon death juristic acts. The upon death juristic act, it is a juristic act which is intended to produce legal consequences when the person who makes that juristic act dies. Okay, the most striking example, it is again a will. When you want to make a will, the will, pinagam. In the common law countries, normally they use the word last will and testament. Okay, but in Thailand, normally we just use the word will. Okay, but it is common practice, means that for for lawyers in common law countries, okay, to use the word last will and testament. Okay, so when you make a will, you want to mention in your will, you want to indicate in your will that when you die, you want your property to go to whom? You want to appoint somebody as as the one who looks after your children, something like that. If you have children, okay, if you have the children who are still minors, of course, means minors we have to be placed with under care of somebody. Let's say that your children do not grow up yet. You have a 10-year-old son, and you just you want to make a will. You may say in the will that you want to appoint Anunampa, okay, as somebody who will look after your son. That's fine, okay. When you write a will, saying that, well, you want your property to go to your son, you want Anunampa to be, somebody who take after, to be the caretaker of your son. Okay, that is what? That is a juristic act, which is intended to carry the effects when you die. So that a will, it is what? It is the upon death juristic act นิติกรรมซึ่งประสงค์ให้มีผลเมื่อตาย See? So now I hope that you have the clear understanding of the during lifetime juristic acts and upon death juristic acts. Okay? Now, right, we will look at some the theories, fundamental theories or concepts, okay, pertinent to juristic acts. Okay, first of all, we will look at the notion or the concept known as what? Known as the party autonomy. What happened to the mind? What happened to mind? The speaker. Something must be wrong. Okay, just now I switch off the sleep function. Okay, but it's still. Wait. It's still the come to sleep. Okay, so that I need to just turn it on again. It's frustrating. Okay, to just turn it on, off again like this. Okay, after just the half an hour, something like that. Okay. So I have to make sure that when something just is put into the correct setting, okay, in order to prevent this symptom, okay, or happening again. Okay. Anyway, we will have a further lecture for about probably half an hour. Okay. Good. Just now we began our class at about 12:25. Now even the 20 minutes, the period of 20 minutes has elapsed after the second half of our lecture. Okay, now we are exploring the fundamental concepts, okay, pertinent to juristic acts. Okay, we are now considering the so-called party autonomy, or sometimes we call this one the sanctity of will theory. Okay, party autonomy. Sometimes the Thai word. I think that some academics use the word หลักอิสระทางแพ่ง Okay, but I do not want you to just remember this one anyway. Okay, remember Thai word. I want you to just understand this one, in the English setting, okay? In the way that this depicts, okay, the theory which holds that a person has freedom to declare their intention. The person has freedom to declare his or her own will in order to make juristic acts, okay, for creating or establishing some legal consequences as between themselves. Okay, A and B, when they make a juristic act, they have freedom to declare their will in the way they like. Okay, that means that it's up to them to just declare their will to make a juristic act. Okay, the parties may make any juristic acts. Okay, even the juristic acts which are not specified by law, they may make any juristic act. The law will have to respect their will or their freedom. Okay, when they want to make any juristic act, they may agree in any way they like. They may agree even in a way which is different from what the law says. They may even agree in derogation from the law. Okay, the law says something. Let's say that when a person make a contract, A and B, they make a contract. Okay, let's say a contract of sale. The law says that if the contract of sale, okay, incurs some fees, okay, then A and B will have to share fees equally. Let's say you need to pay tax, you need to pay fee. The law say that A, the seller, and B, the buyer, will have to pay equally. They will have to share fees or taxes equally. Okay. Even the law says so, A and B may agree differently from what the law says. the contract may say that, well, all fees will have to be borne. They will have to be, borne by A only. B is not required to pay any fee, any taxes at all. Right, so that means that the party has what? The parties have party autonomy. They have freedom to declare their will or their intention in any way they like. They may make any juristic act. They may agree on the contents of the juristic acts in question, in any way they like, even in derogation from the law. So that the agreement between the parties, the agreement between the party, takes precedence over the law. That means that the agreements between the parties prevails. When the agreement between parties, take precedence over the law, we can call the agreement between the party as the law of the party. It is the law of the party because they set their own laws, even in a way, differently from what the law say. If you prefer the French term, normally when we have a French term here, droit de partie. Droit mean law, partie mean party, droit de partie, that is the law of the party. The agreement between the parties serve as the law of the parties, so it just overrides what the law says. Right. So this is the meaning of the party autonomy. So put simply, party autonomy, it is a what? It is the freedom to declare the will, in any way, In the context of contracts, the party autonomy is known as the freedom of contract. So the freedom of contract, it is the party autonomy in the context of contracts. So in a way, freedom contract, it is what? It is the freedom to declare their will, the party's freedom to declare their will in making a contract. They can, first of all, they can decide whether or not to enter into the contract. A and B may decide whether or not to enter into a contract. Nobody can just force anyone to enter into a contract. It's up to A, it's up to B to enter into the contract. It's up to A, it's up to B not to enter into a contract. And A and B, the parties, also enjoy freedom to fix the terms or the contents of the contract. They have the freedom to fix the contents of the contract. They can decide their own contract terms. They can even decide the contract terms which are even different from the requirements fixed by the law. Just now, I gave you an example. Remember, let's say in the contract of sale, the law says that the seller and the buyer will have to share the fees equally. Correct? In the contract made between A and B, between the seller and the buyer, the contract specifies that A alone will have to pay the fees and taxes. So when A and B say so, when A and B agree so be it. The agreement between A and B will prevail. It will what? The agreement between A and B will take precedence over the law, so that it is the droit de partie again. See, when A and B enjoy the freedom contract in a way that they can just have the freedom to decide whether or not to enter into the contract, and they can just decide the contents of the contract between themselves. When they decide to enter into the contract and they decide the contents, then the state will have to respect their decisions. The state must enforce the contract made by the parties. The contract as made or concluded between the parties will have to be respected. Okay, it is not the function, it is not the duty of state to just intervene. The state may intervene only in some special circumstances, in very, very exceptional circumstances, but in general, the state will not intervene. Okay, in the agreement between A and B. The agreement between private individuals will have to be respected by the state. Okay, so I think that most of you here must have been aware of the Latin expression pacta sunt servanda. Pacta sunt servanda, what agreements must be kept. Agreements must be the agreement or contracts must be respected. Okay, so that it is not the duty of state to just intervene. Just now, we have seen that freedom contract depicts three things. Okay, first, freedom to enter or not to enter into a contract. Secondly, freedom to fix the terms of the contract, and thirdly, freedom from intervention by the state. Okay, if we come back to the first one, freedom to enter or not to enter into a contract. Okay, we can see that, okay, before a contract is finally concluded between A and B sometime, okay, carry out negotiations. There may be many rounds of negotiations before a contract is concluded. Okay, so during the negotiation, okay, A and B have freedom of contract. They can just decide whether or not to enter into contract. If, for instance, if A does not want to enter into contract after the negotiations, after a long series of negotiation, A said, no, I'm not going to enter into contract. I'm not going to make a contract with you because I don't think that it's worth. Will A have any liability? In the many jurisdictions, okay? During the negotiation, nobody will have any liability. Right, but in some jurisdictions, when I say jurisdictions, that mean countries, okay? In some countries, the laws of some countries impose some liability for breaking off negotiation in bad faith, even though normally during the negotiation period, nobody will have any liability, but in some countries, okay, in some jurisdictions, let's suppose that A, okay, after a long series of negotiations, that series of negotiations, okay, creates B's reliance that A will enter into the contract finally. But A just breaks off the negotiation in bad faith. Okay? Breaking off negotiations in bad faith may also carry some liability in some countries, not in this country normally. In Thailand, okay, our law does not have the clear idea about the liability before the contract, okay? Liability before the formation of contract, okay? What happens before before a contract is formed does not create liabilities. This is general image of Thai law, but in some country law, for instance, in English law, okay, if A just stop the negotiation, if A just breaks off the negotiation in bad faith, okay, then the A will have to be liable to B, okay. But again, this is not, the general treatment by Thai law, okay. In Thai law, okay, if A does not want to enter into contract, then the A will normally not have liability, simply because that is the pre-contractual context, okay. When they say that in some countries, okay, they have the law which in a way imposes some liability on the parties who breaks off negotiation in bad faith, that is the so-called, pre-contractual liability เอาความรับผิดก่อนสัญญา Culpa in contrahender, but you don't need to just pay attention to this much, okay? Because this is not taught normally, I mean, at the level of the LLB education, okay? But that is something to be explored, okay, at the postgraduate level, okay? If you are interested in knowing something like this, then you can just proceed to the LLM degree, okay, the graduate studies. Now, just now we have seen that, the party autonomy depicts the freedom to make juristic acts, okay? And also the freedom contract, it is the freedom to make contracts. You may make decision whether to enter into the contract, and you may also have your freedom, okay, to decide contents of your contract in any way you like, even in a manner which is different from what the law says, okay? That is what we have seen, okay? Does it mean that this party autonomy doctrine, what is it, doctrine, okay, that is the principle, okay? Normally when you are not quite accustomed to the word doctrine like this, okay? Normally Thai students may perceive the English word doctrine as in Thai lakti, but this is not lakti in Thai, okay? When we say doctrine, like normally the doctrine in contract law, it is the principles of contract law, okay? หลักกฎหมาย in the English law, normally if you read textbooks, you can come across the use of the word doctrines quite a lot. Doctrine of mistake หลักกฎหมายเรื่องความสำคัญผิด the doctrine of misrepresentation หลักกฎหมายเรื่องการแสดงข้อความอันเป็นเท็จ something like that, okay? So doctrine here, it is not lakti in Thai, okay? Back to this one, the doctrine of party autonomy, okay, is subject to certain legal restriction or limitation, okay? That means that even though parties have freedom, but they do not enjoy absolute freedom, because in some situations, the party's freedom, the party autonomy, is subject to some limitations. Okay, there are at least these three limitations. The first one is public order, ความสงบเรียบร้อยของประชาชน okay, public order. Okay, in French, okay, if you know French, okay, l'ordre public. It is quite difficult to just pronounce. Okay. L'ordre. See, ordre. Hello. Okay, my microphone sometimes dies. Okay, so public order. Okay, that is one restriction or one limitation. One limitation which is attached to the party autonomy doctrine, okay? The second one is public good morals. ศีลธรรมอันดีของประชาชน Sometimes we use these two words together, okay? Public order or the public good morals. Public order or good morals. Sometimes we use the word public. We share the word public here, okay? Public order or good morals. ความสงบเรียบร้อยหรือศีลธรรมอันดีของประชาชน okay? And the last restriction, it is the restriction which is imposed by law, by specific law, statutory prohibitions in law, okay? Even though parties may enjoy freedoms, but the law, some laws, okay, some pieces of legislation do fix some prohibitions, okay, by some reason, okay. Let's say that we have, one piece of legislation called the Unfair Contract Terms Act. The Unfair Contract Terms Act, okay, 1997. In fact, this act has been modeled, okay. This act has been much influenced by the English Act, with the same name, okay, Unfair Contract Terms Act of the UK, okay. In the UK, they have this act of 1977. Okay, we call this one UCTA, UCTA, UCTA. The Thai UCTA it is the product of borrowing the concepts from the UK UCTA. Okay, the Thai UCTA has some mistakes as well, but I don't think that I'm going to talk about this now. Okay, normally when I will talk about this, I will discuss this at great lengths at the LLM level, okay, rather than the LLB level. Okay, so in this act just imposes on parties some limitations with regard to fixing the terms of the contract. Let's suppose that you make a contract. My God, one more time. Okay, this one just stopped. I need to just switch it on again. Very, frustrating that it just stopped from from time to time back to this one. Good. I hope that this is the last one for today. Okay, before we end the class in about the 15 minutes time. Right? I will try to finish off this slide anyway. Right. Let's suppose that we have a contract of sale. A contract of sale between him and him. A contract of sale. Let's say that I want to sell what? I want to sell this computer, this notebook. I want to sell this smartphone. Okay, let's say that I am the what? I run a telephone shop. I run a mobile phone shop. And I sell this mobile phone shop to, there are many customers. You come to my shop and you want to buy one of these mobile phones. Okay, and I make a contract with you. I put in the contract a clause saying that if this phone doesn't work, after you get the phone and when you just step out of my shop, if this phone breaks down, if this phone cannot function, then I will not be liable at all. I'm not going to be responsible. Can I do so? Doesn't mean that I have the freedom of contract or I have the party autonomy to just specify in this contract like this. Okay. Normally, if there is no specific law, okay, imposing prohibition, then the party may do so. The party may specify in the contract that they will not be liable for the defect. Right? But in this case, the ACTA, the Thai ACTA, Unfair Contract Terms Act, 1997 say that, well, this is not allowed. If you look at Section 6. If you look at Section 6 of ACTA, UCTA, Section 6 say that a contract as between a consumers and a trader, okay, which involves delivery of property to consumer, may not contain a term excluding or restricting the trader's liability for a defect. See, so when I have a clause in the contract saying that I am not going to be liable or responsible for any defect, okay, which occurred to this mobile phone, okay, that is not possible because this Section 6 prevents me from doing so. This Section 6 of ACTA, okay, does set the prohibitions against this use of the term. Okay, so in a way, the party autonomy or the freedom contract, it is subject to certain limitations, including statutory prohibitions. Okay, so if there is no, the prohibitions by the law, then that means that you can just make agreements. You can just decide contract terms in any way you like. You can just decide contents of choosing acts in any way you prefer. Okay, so that is one thing to be understood. Okay, again, right. Now, when we talk about the party autonomy doctrine, you may ask me the question, okay, where this doctrine, where can we find this doctrine in Thai law? Well, this party autonomy concept is found in the CCC itself. It is in particular in section 151. 151 of the CCC. 151 provides as follows. For one thing, okay, I give you the English translation of the CCC. And this English translation is prepared by me. Okay, that is my copyright. I have intention, okay, to just prepare the whole translation of the CCC, the entire book, to be published. Okay, at the end of this year. Okay, so please do not infringe copyright in my work. Okay, I allow you to use the English translation like this. Okay, you may say, well, there is also English translation. Okay, elsewhere. And for one thing, maybe you don't know yet. Okay, when we made our law in this country, when we drafted the law in this country, the CCC, when it was first drafted in English, and it was translated in Thai later. The reason why it was first drafted in English is because at that time we hired foreign experts to draft law. Those foreign experts, they did not know Thai, so they drafted the law in English first. And then after that, the English text, okay, were put into Thai text, which now become the civil and commercial code. Okay, somebody just got the English translation from the early draft and published for sale, but they did not prepare translation by themselves. They just got the previous English translation, the English text, not translation, the English text. Okay, in fact, they do what? They have done the compilation, not translation. They just did translation, okay, with respect to some provisions which have been, added into the law later. But the texts, the English texts which were put in those days, they were too old. They used sort of the old English, okay, so that and sometimes you can see that when we just translate it into Thai, which appear in our CCC, okay, the text seem to conflict. The Thai text say one thing, English text say something else, so that there is some discrepancies between the English text and the Thai text. I'm sure that when the court apply the law, the court will not consult. The court will not look at the English text; they will look at the Thai text. So when I prepare my translation of law, I will just do it the whole thing. Okay, I will just prepare the new translation. Okay, I try to make sure that the language, it is the language nowadays. It is not the old language. Okay, so you will just see my work at the end of this year. Okay, it is on the way now. Okay, I try to be in a hurry. Okay, to just finish this work. The thing is that I have too much work to do. Okay, in fact, I intended to just finish this work last year, but this work has been now delayed. But I have intentions. Okay, I have an intention, clear intention indeed, to just finish off this work this year. So when I just let you use it, okay, please respect my copyright. Okay, back to 151. 151 provides as follows. Okay, any act which differs from a provision of law is not void if it is not the law relating to public order or good morals. When you just look at this provision, we can see direct meaning and also implied meaning. The direct meaning, it is a meaning which is said by 151. The direct meaning is that a person may, enjoys freedom to decide contents or substances of a juristic act. And sometimes, I use the word juridical act. The word juristic act and juridical act, they are the same. In fact, the most proper one, it is the juridical act. nitikam. But in this country, okay, we have used the term juristic for, I think that for the almost 100 years. Okay, so that means people now in this country seem to be used to the term juristic act rather than the term juridical act. Okay. Now, back to the direct meaning. The direct meaning it is what is exactly said in 151. A person may just, a person enjoys full freedom to do what? To just, decide the contents of the Juristic Act. Okay, they may even go against the law. They may just decide, the contents of the Juristic Act, even in the way different from what the law say, in a way which is different from a provision of law. But when the law says one thing, A and B, the party may enter a Juristic Act, may enter into a Juristic Act, and may decide the contents of that Juristic Act in a way, different from a provision of law, provided that provision of law it is not related to public order or good morals. If that provision of law relates to the public order or good morals, A and B may not agree, differently from what the law says. We are going to look at example later. This is the direct meaning of the party autonomy. The direct meaning of party autonomy as embodied in section 151, but there is also an implied meaning. The implied meaning of section 151 is this one. A person may also enjoy freedom. Freedom to do what? Freedom as to whether to make a Juristic Act or not. 151 say that, well, you have freedom, to agree on contents of a Juristic Act. But you may have you have freedom to agree on the content. If you have freedom to agree on the content, you can, by way of implication, you should also have the freedom at the beginning. You should have the freedom even at the beginning to make decision whether to enter into that Juristic Act. So this is the implied meaning which flow from section 151 as well. So again, if you ask me a question where we can find the party autonomy principle in Thai law, the answer is that this party autonomy or the freedom contract, it is found in section 151 of the CCC. Right. Now, back to 151. 151 say that everyone has party autonomy. Everyone has the freedom of contract. We can just make a Juristic Act. We can just make a contract in any way we like. We can even agree, in derogation from what the law says. Provided that law is not concerned with public order or good morals. I give you examples. I give you some examples here. Let's look at the example number 1 here. In this example number 1, my God, I'm so excited because the time is going to be up very soon. We are going to look at a list. A list is what? A list is Sanya Chao. Our CCC. If you look at the English version of the CCC as prepared by by the foreign experts at the old time. In the old time, they use the word high of property, but I prefer the word list because list it is used worldwide. Is it a term used worldwide? In the list, of course, there are two parties. The first one is called the lessor, or we can also call lessor, okay, ผู้ให้เช่า and the other one is the lessee or the higher ผู้เช่า okay. Let's suppose that means that you want to just rent a house, you want to take a lease of this house. Sometimes, let's say that when you rent this house, you make a contract, A and B, supposing that A and B, they make contract, a lease, whereby B take this house on lease, okay, for 2 years. Let's suppose that after 6 months, this house has some defect. You may have to repair, okay? We need to repair this house. Who is going to be liable for the cost of repair? The law says this. We have section 550 and 553 of the CCC. 550 and 553 say that, well, the cost of major repairs will have to be borne by the lessor, but the cost of minor repairs, or we can also call petty repair, minor repair or petty repair, some assembly. The cost of minor repairs will have to be borne by the lessee. Okay, so lawyer just remember this way. Well, major repairs are under responsibility of the lessor. The minor repairs are under responsibility of the lessee. This is what the law say. Even the law says so. A and B, when they make the list, when they conclude the list, they can just say in the list that all repairs shall be under the responsibility of whom? Let's say that they may say that all repairs, the cost of all repair will have to be borne by the lessor only. Fine. The law say one thing. The law say that the cost of repair shall be shared. But the parties, lessor, lessee, may agree that the lessor will bear all costs of repair. Fine. So the agreement between A and B just take precedence over Section 550 and Section 553 of the CCC, and Section 550 and 553 of the CCC, they are not the provisions of law which deal with public order or good morals. So as long as the law says something which is not concerned with public order or good morals, parties to the contract, parties to juristic acts may just agree otherwise in the way, okay, in derogation from what the law says. All right. Now, I'm coming to the example number 2. In the example number 2, let's say that we are concerned with the hire purchase. Hire purchase. This is one of specific contracts. Okay, the Thai term for hire purchase, it is สัญญาเช่าซื้อ You can see that hire purchase, it is, in order to just make you understand this one first, the hire purchase, a hire purchase, it is what? It is a combination between two things, combination between a lease, hire the lease, and a sale. The purchase is a sale. See? It is a combination between a lease and a sale. Okay. It is a lease plus a promise to sell, a promise to transfer ownership in a property. Okay. Let's suppose that, okay, if I give you the more explanation on this one, let's suppose that Nobita and Conan, they make agreement. Nobita has a car. Nobita and Conan enter into this contract whereby Nobita rent this car out to Conan, and Conan will have to pay the rent. Let's say that they agree that Conan will pay the rent for 36 months. Okay, so each month, during the period of 3 years or 36 months, Conan will have to pay the rent in an amount of 30,000 baht. Okay, if at the end of, let's say that they fix the term of the lease for 3 years or 36 months, at the end of 36 months period, if the contract say that Conan will have to return the car to Nobita, that is just the normal lease. But if the lease goes further, to say that, well, at the end of this 36-month period, then Nobita, the owner, will transfer the property ownership in this car to Conan. That is the hire purchase, because it is sale plus the promise to transfer ownership to whom? To the lessor. See, so a hire purchase is in a way a combination between a sale and a lease. It is a lease. Okay, it is a lease in a way. A hire purchase. Hello. Okay, now, hello, now. Again, a hire purchase is a combination between a lease and a sale in a way that it is a lease plus, plus a promise to sell or promise to transfer the ownership. Okay, now that is what the law say. Okay, if you want to look at the provision of law which says something about the hire purchase, go to section 572 of the CCC. And now what we are going to say in this one. Okay, let's suppose that. Okay, let's suppose that Conan, it is back to Conan and Nobita case here. The contract, the hire purchase contract say that Conan will have to pay the rent every month in the amount of 30,000 baht. But at the end of the 36-month period, then Nobita, the owner, will transfer ownership in this property to Conan. Right. What happens if Conan does not pay the rent? Can the owner, in this case Nobita, terminate the contract? The law say this one. We get section 574 of the CCC say that if the hire, we call it ผู้เช่าซื้อ okay, we get a two term. Okay, in a hire purchase we have two parties, the owner and the hire. Okay, the owner and the hire. If the hire does not pay the installment, if the hire does not make installment payment, then the owner may just terminate the contract, provided that the defaults occur two times. The defaults occur two times, successively or consecutively. ผิดนัด2 งวดติดกัน the Thai expression is ผิดนัด2 งวดติดกัน. Okay, if back to this one, if Conan does not make payment of the rent, or we can call it installment payment. Okay, if Conan does not make this installment payment, then the owner, in this case Nobita, can just terminate the contract when defaults occurs two times consecutively or successively. Okay, this is what the law say. Okay, even the law say this. Okay, a contract between the party may say otherwise. A and B or Nobita and Conan may agree otherwise. A contract between Nobita and Conan may say that, well, even when Conan just defaults on only one payment, that is enough for Nobita to exercise the right to terminate the contract. Nobita can just terminate the contract when Conan defaults on only one installment payment. Fine. The law say that the owner may terminate the contract when default occurs two times consecutively. Okay, but the parties to this agreement may agree that even when the default occurs only once, then that is a ground for termination by the owner. Fine, If you look at what the law say here, it is contained in section 574, In case of default of two successive payments, ในกรณีผิดนัดไม่ใช้เงิน2คราวติดกันเนี่ย In case of default of two successive payments, say the owner of the property may terminate the contract. See, even the law say this, the parties may agree differently from what the law say. That's why the parties say that, well, even the default occurred on only one payment, then that is the ground for termination, In fact, there is a real story, which has been brought before the Supreme Court. The example is the decision of the Supreme Court number here, the 5971/2544. You don't need to memorize, You don't need to memorize. In my class, you don't need to memorize two things. First, provisions of law. I do not expect you to memorize the wording, but I expect you to understand the contents. I just require your understanding rather than memorization of the wording. You don't need to memorize the wording. You can understand the content, saying that, well, the law say that, in the case of defaults in high purchase, in order to terminate the contract, the default need to occur 2 times consecutively. Fine, you don't need to go through the wording, exact wording. No exact wording is required because my class is the class intended to create your understanding, not the class intended to test your memory or memorization. No, that is one thing which you are not required to memorize. The second thing which you are not required to memorize is the numbers of the decision of Supreme Court. You don't need to tell me, well, the decision of Supreme Court number, number 9571/2544. No, because I cannot remember myself. I myself cannot remember this, and it is a waste of time to memorize this. Understanding counts. Understanding, is more important than memorization of the wording. So this is the example of the droit de partie, which is which takes precedence over what the law say. Again, when the law says something, you may agree otherwise. You have the party autonomy. You have the freedom contract to agree otherwise in derogation from what the law say, provided that what the law say it is not relating to public order or good morals. If you are interested, you can just have a look at more example. But I try to skip the another 2 more example because this is similar to example number 1. If you have time, you can go to example number 2, number 3, and number 4. Now, remember, I now come to slide number 46. I leave example number 2, 3, 4 to you, for your self-tuition, because the facts are similar to example number 1, which I have brought to your attention. Now remember, 151 says that you are welcome as the parties to a juristic acts. You're welcome to agree on the contents. You may agree. You may decide the contents of a juristic act, even in a way in derogation from what the law says, provided that what the law says it is not relating to public policy or public order or good morals. Sometimes we need to look at the provisions of law carefully. If the provisions of law relates to public order or good morals, you may not agree in a way derogating from those provisions of law. Okay, there are some ways to know whether or not provisions of law deal with public order or good morals. The first one is this: if we come across provisions of law which are aimed at protecting the family institution, that means that those provisions of law are concerned with public order or good morals, because nobody wants the family institution to be undermined. Okay, let's suppose that the provisions of law which say something about the parental power, let's say that when the parents A and B, their parents A and B have a son, and one son. The son will have to be under parental power of both A and B. The parents will have the parental power if husband and wife, if they have a kid, and they make contract saying that, well, only the husband will have the parental power over the son. That agreement is fine or not? The answer is no. You cannot make the agreement to the effect that the parental power will fall on A alone, will fall on the male partner alone. Okay, we have A, the male, and B, the female one. The husband and wife may not make an agreement saying that, well, the parental power will rest in A only, not B. Because if you just agree that way, that is the agreement which is contrary to provisions of law which are intended, okay, to protect the family institution, so that those provisions of law deal with public order or good morals. You may not say that, well, I have the party autonomy to make an agreement like this. Remember, a very important restriction or limitation. Okay, the limitation of the party autonomy principle is the public order or good morals. You may not agree, okay, in a way different from what the law says, if the provisions of law or that matter deal with public order or good morals. Now, the next one is this: if we come across provision of law which are intended to protect third parties, then that will relate to public order or good morals. Let's suppose that we have the requirement in the law. If we make a contract of sale of a house, the law requires us to register the sale. The law requires us to make the sale in writing and register the sale. The requirement as regards writing and registration, that is intended to protect third parties. Because if the law requires that, well, when you make a contract of sale of the house, you need to make it in writing and you need to register it at the land office. That is to make known to the public as to the title or the rights in this land. Anyone can have a look at, the title deed, to find out the owners. So the requirement with respect to, the making the contract in writing and also registration of the contract, those requirements, they are intended to protect third parties, so that the provision of law which require writing and registration like this, they are concerned with the public order or good morals, and nobody may make agreement, okay, in a way differently from those requirements in the law. Okay, so you cannot say that, well, between us, okay, we can make a contract, okay, just verbally, not in writing. You cannot say so, because if you do so, then your contract will be void. Now, provisions of law which are intended to protect persons of disability, persons who have some weaknesses, they are concerned with public order or good morals. Let's suppose that we have the labor protection law, กฎหมายคุ้มครองแรงงาน okay in our country we have the labor protection act พระราชบัญญัติคุ้มครองแรงงาน okay this act of course as the name suggests protect laborers, protect workers are entitled to have what, to have for instance minimum wages, they are entitled to OT, overtime payment. They are entitled to severance payment if they are asked, by the employer to leave the employment. They are entitled to severance payment. Okay, the ค่าชดเชย right? So the reason why the law, okay, require this is to protect workers. The workers are persons of disability. So those provisions of law, they are concerned with public order or good morals. Nobody can make any agreement, okay, in the way differently from what the law say. Let's say that, okay, a company just make agreement with an employee saying that, well, okay, in this company we don't pay OT. All workers who work at this company need to waive the right to OT. If I put this in this contract of employment, สัญญาจ้างแรงงาน can I say that, well, fine, this clause is fine because I enjoy, freedom contract, I enjoy party autonomy, so that, this clause seems to be fine. Can I say so? The answer is no, because I cannot agree, okay, in the way different from provision of law which are related to public order or good morals. Back to 151. 151 say what? We are back to 151. 151 says that, now I'm back to 151. Any act which differs from a provision of law is not void if it is not the law relating to public order or good morals. If you agree on something differently from what the law say, fine, okay, because your agreement will prevail, okay, but you need to make sure that what the law say, it is not something which deal with public order or good morals. If the provision of law deal with public order or good morals, you may not agree, okay, in the way derogatory, okay, derogatory from what the law says. So just now we make a mention of a contract of employment which say that the employees, okay, would not be entitled to OT. Okay, in this case, the agreement cannot stand. The agreement cannot stand because it is an agreement in a way differently from what the law say, but that provision of law, it is something dealing with public order or good morals, so that nobody can just, escape the provision of law which deal with public order or good morals. Okay, if you have time, then you can just go to look at another decision of Supreme Court, okay, which has similar facts. Okay, so I think that I cover, the important things for today. Okay, so that then we can just finish the lecture. Okay, the first lecture now. All right. If you have any question, you can address your question to me. Okay, via line, or that you can leave your message. Okay, in the Facebook. Okay, in our private group on Facebook. Okay, I am delighted to entertain your questions. Okay, I hope that the teaching this morning is useful to you. Of course, in the first lecture of this term, okay, you are new to the English, okay, the teaching like this, okay, so that I hope that next time you will be fine, okay, you will at least get yourself used to my accent of my teaching like this, okay. I'm not quite sure whether the speed of my lecture is okay or not, okay. Maybe from time to time go too fast because I need to make sure that everything is going to be finished on time. Sorry if I go too fast, okay, but I'm sure that you can just go back. If you cannot, catch up, some part of my lecture, you can go back, to the PowerPoint presentation file, okay, to just, look at the details later, okay. Hopefully, you will be fine very soon. Thank you very much again for your attention, and see you again next Monday. Thank you.